This podcast is entertainment, not financial, tax, or legal advice. Views expressed represent statements of the speaker in their individual capacity, do not represent the views of Unchained, and should not be considered investment advice. Speakers often have personal, family, or business connections to Unchained, which may include direct financial benefits. Please see our disclosure at unchained.com/podcast.
We are living through a pivotal moment. Lawmakers are drafting the rules that will define what financial freedom means in the digital age, legislation that could shape the rights of Americans for generations to come. The Last Free Americans examines this moment through the lens of Bitcoin self-custody, the intersection of law, technology, and human sovereignty. This series explores the precedents and pressures shaping this new frontier. Here's our conversation. I really hope you enjoy it.
Thanks for doing this, Zach. I gave you some info. If you looked at it, I've kind of, it's a passion project for me, and any of us at Unchained, just I think trying to bring more light, shed more light on the issues surrounding self-custody. I think it's cool because it's a topic you can focus in on very widely. You're like going back to like the framers and the Constitution and Bills of Rights to like today and a lot of the very active stuff. So my goal or my intention for a lot of this conversation is to, cover kind of as much of that as possible, really at a lot of different levels. And so just more on common ground basis, like I'd love your thoughts, your feedback, or just how you think about this kind of initiative and its timeliness, and like why is it important today to like make these issues clearer?
For sure. What in particular would be helpful for me to talk about?
Self-custody. What does it mean?
Self-custody is a really big topic. I think fundamentally self-custody is a big part of what gives Bitcoin its value. It is that just like the sort of core unlock of Bitcoin is that you can send money electronically without an intermediary, you can also custody your money without the need for a custodian or intermediary or clearinghouse or anything like that. And so a big part of what makes Bitcoin what it is just the ability to self-custody, specifically with regard to Bitcoin, the asset. And then with regard to Bitcoin, the network, what makes the network valuable, what makes the network permissionless, what makes the network so powerful as a freedom tool is the ability to do peer-to-peer transactions, which also depends on the right to self-custody. Being able to self-custody is just logically a prerequisite to being able to send a transaction on a peer-to-peer basis. So self-custody really underpins what Bitcoin the asset is about, what Bitcoin the network is about, and really the benefits you get both from a value perspective, from a number go up perspective, and also from a sort of freedom go up or censorship resistance perspective. Why is self-custody especially important now when we're talking in the summer of 2025? I think there are two primary and parallel reasons why. One is we are getting to, I think, the first time in Bitcoin's history where a lot of the discussion around Bitcoin, the narrative, the energy, the buzz around Bitcoin is pretty detached from sort of traditional ways of holding and using Bitcoin, and specifically from self-custody. With the launch of Bitcoin ETFs in early 2024, more and more people are getting economic exposure to Bitcoin who are not actually touching the asset or the network itself. Bitcoin is fusing with traditional finance. Bitcoin is fusing more with politics and with geopolitics. And in order to have Bitcoin fulfill its full promise, I think both in terms of purchasing power and in terms of how it can change the world, it is important to maintain a grounding in the ability and desire and individual capabilities to self-custody. Both sort of to help the asset and the network, but also to help users who want to navigate a volatile period in time where Bitcoin takes a bigger role on the world stage, risks about wrench attacks, risks about confiscation, bail-ins from governments, failures of intermediaries, including custodians, including asset managers, funds, treasury companies. I think navigating through this time, self-custody is an incredibly powerful and unique tool for Bitcoin holders. So that's sort of track one. And then track two is that we are in a unique moment in time in sort of the development of Bitcoin and the intersection of Bitcoin with pre-existing laws and regulations, at least in the United States, where our legal structure, which was designed for a world where if there are electronic transfers of money, necessarily that would have had to involve a regulated financial intermediary, because that was the only way you could electronically transfer money before the creation of Bitcoin, to a world where peer-to-peer electronic transfers are possible and happen every day. And either the law is going to catch up with that fact, either through legislation being passed to modernize, for example, our illicit finance rules, or in terms of case law that's made by judges who have to look at this issue, where there is a company or an individual that's charged with a crime related to the Bank Secrecy Act or illicit finance laws, and there isn't an intermediary because the company or individual is running a service on a non-custodial basis. There isn't a financial intermediary that the law would presume is there, and so you can either hold the person who built the tool responsible, or the government's not going to be able to do a prosecution. And so the sort of options here are we need to integrate this new paradigm into our laws. We need to teach it to judges. We need to teach it to Congress, or it's going to be an increasingly difficult period to build and use non-custodial technology in the United States, including custody of Bitcoin directly. If someone is going to be thrown in prison for creating a wallet, which is at its base a piece of software that helps you generate private keys and helps you generate addresses and helps you write transactions that you can broadcast to a node. If the person who writes that software runs the risk of going to prison for publishing it, if the person who runs the node, if you're not running your own node, who broadcasts your transaction that you're signing with your private keys, is going to go to prison, it's going to be really hard for you to self-custody. And so we need to sort of press on all fronts in the courts, something we do through the Peer-to-Peer Rights Fund at BPI, or on Capitol Hill. And right now, as we're recording this, the big effort to do this is Section 109 of the Clarity Act that passed through the United States House of Representatives, and a companion bill is up for review in the Senate, to help cross this divide, where we could either sort of get this right and America can fulfill its promise as the Bitcoin superpower, and we can move forward building all of the amazing scaling technology for Bitcoin that we need, or we can continue to have this war between the federal government and software developers that is an echo of the crypto wars in the 90s, where the government tried to stop strong cryptography before it became a widespread part of the economy.
Yeah, and an underpinning of like the whole internet now. So through a couple of the things there, and I want to get to the Clarity Act, but for some of the things you said, would you say Bitcoin is like not worth whatever trillions of dollars it is today if it didn't have self-custody as a feature?
It would be worth less, for sure. The easiest way I think a lot of people who are just beginning to understand Bitcoin think about a valuation metric is to start by comparing it to gold. And as long as Bitcoin is worth less than gold, the market cap of Bitcoin is lower than the market cap of gold, I think that's just a strong signal that Bitcoin is undervalued, because gold overwhelmingly is valued for its monetary properties, not for its industrial use cases. There are lots of things that have industrial use cases, but really it's the things that make gold good money. It's scarcity, fungibility, durability, etc. Bitcoin has all of that, but better, and it's digital. But one of the important things you can do with gold is you can custody it yourself. You can audit whether the gold is real through an assay, not as easily as you can do with Bitcoin, but and so if we start to lose some of the fundamental properties of Bitcoin, like the ability to hold it and verify it yourself, and to transact on a peer-to-peer basis without needing some sort of third-party centralized ledger or permission of a government or a clearing agent, that undermines fundamentally the investment case for Bitcoin.
Yeah, wholeheartedly agree. From the perspective of, because you talked about self-custody's importance to Bitcoin, can you talk about the importance of self-custody like more broadly? And what I'm interested in is also trying to draw from your law background, like some of the constitutional history in the context for this stuff? Like when have we had to answer questions? Cryptography is one example, but like just as a legal system in America, referencing like the liberties and principles that the framers wanted to preserve for us, where has self-custody shown up, or where has the kind of issues involving self-custody shown up like over that time? What's involved?
Yeah, I think there are a lot of ways in which the ability to self-custody Bitcoin intersects with American values that are in our Constitution and in the history of our country. One is that self-custodied Bitcoin in particular, I think, is probably the purest embodiment of property rights that humans have conceived of. Being able to hold an unlimited amount of capital by memorizing a seed phrase that only you know is such an intimate way to hold property. Interestingly, from a legal perspective, I think that means that the ways that someone can get you to give up Bitcoin will face real constitutional challenges. Someone can, a judge can issue a court order that you have to turn over a certain amount of Bitcoin, and yes, that's legally binding. But there are Fifth Amendment protections against doing stuff that is self-incriminating, which might include giving up a seed phrase that would basically give evidence against you for some crime. You basically have to torture someone to absolutely force them to give up a seed phrase, and that's not something that you can do in the criminal justice system in the United States. And so, having the ability to hold something in that way, protected by specifically all parts of the Bill of Rights, I think is really, really powerful. In terms of like constitutional protections, like if we're actually going to go through where does the Constitution protect your ability to self-custody, and I think it very much does.
Yeah.
There are a number of different. So the first 10 amendments to the Bill of Rights, to the Constitution, are called the Bill of Rights. Those are the sort of basic individual rights that every American has, and I think you can point to like half of them as pretty strong protection for self-custody. So one very obvious one is to start with the First Amendment, which is freedom of speech, freedom of assembly, especially freedom of speech in the context of political views. You can issue speech on the Bitcoin blockchain. You can use sort of the Bitcoin network as a way to peaceably assemble in a way that's protected by the First Amendment. First Amendment protects your ability to write or publish code, which can definitely be something that you do in the context of self-custodying Bitcoin, especially if you're running your own node or writing your own custody software, which not everyone's going to do, but there's definitely First Amendment protections. The Fourth Amendment, I think, is very powerful. The Fourth Amendment protects you against unreasonable search and seizure. A lot of what the government would have to do to confiscate Bitcoin that you're self-custodying would seem to be a pretty straightforward Fourth Amendment violation, absent really good legal reason to do so, a warrant, probable cause as to a certain crime, and so Fourth Amendment gives strong protections against sort of preemptive prohibitions on self-custody, or I would say a ban on privacy tools, since that can be a sort of unprompted dragnet level of surveillance. So it's both search and seizure in the Fourth Amendment. And so banning privacy tools could be seen as just a search. The Fifth Amendment gives you the right to due process. So I would, and the Fifth Amendment's been interpreted in all sorts of ways, including with a penumbra of rights and prohibitions against the government just imposing arbitrary laws. And so the ability to hold Bitcoin absent sort of due process for the government to take it away, I think is strongly protected. There's a doctrine called substantive due process, which are sort of fundamental rights that people have, and that provides the legal basis for a lot of constitutional protections. I would say that the ability to transact, the ability to hold your own wealth where your wealth is being capable of being held, I think there's a strong substantive due process argument.
Article 5, is that also where like impingement to eminent domain, like the part of it's that the government can't take property without just compensation?
So this is the Fifth Amendment, which is different than Article 5.
Okay.
But in order to exercise its eminent domain right, the government has to pay you fair compensation, and the Constitution limits that. But the Fifth Amendment is a blanket right to due process, which I think is really important for self-custody protections. The Ninth Amendment says that the rights that are not given to the government are retained by the people, which is another sort of blanket prohibition against sort of arbitrary lawmaking. The example that people in law school give a lot about Ninth Amendment protections: the government can't pass a law that says you have to sleep on the left side of the bed, right? There's no particular constitutional prohibition against that, but that would be the type of thing that is retained as a right by the people. And I think that's another strong argument you can make for Bitcoin self-custody. And then the 10th Amendment, which leaves to the various powers to the states, including the police power, is probably a pretty good right there too. And then the 14th Amendment, which is another version of a due process right, would be helpful here. So there's a lot of intersection between constitutional rights and the right to self-custody. Any challenge to self-custody directly, I think, would have to face all of those arguments. Actually, for this reason, I'm not in favor of a lot of these state laws that are popping up that purport to create a right to self-custody. I think that sends the wrong message, especially when they're passed on completely partisan lines. I think we have a right to self-custody. And if you were to look at there is self-custody language in the Clarity Act, and specifically that language says that it recognizes a pre-existing right. It was carefully drafted to recognize all of these pre-existing constitutional protections. And so that's an important thing to keep in mind. And then if we look at American history, what are the other things you can learn from, there's a famous example of Executive Order 6102, where it became illegal for Americans to quote unquote hoard gold. That rule was enforced against Americans who held their gold in bank vaults. It was not enforced against Americans who self-custodied gold. And so looking into history, both in the United States and in Europe with the world wars, where people were or were not able to flee with their wealth, and it's very hard to flee with a lot of gold. You couldn't trust the banking system at the time. The sort of property rights inherent in the ability to self-custody a digital asset like Bitcoin are just very powerful protections that you don't have to go that far back in history to see how that would have been useful in a whole host of situations.
Yeah, I'm glad you brought up the 6102 thing, because in just kind of looking at this stuff, that's why even the eminent domain type example is on my mind, because I think I've forgotten detail that doesn't always get mentioned in Executive Order 6102 is that the government did pay the people for the gold, or at least everybody complied, or ultimately
after marking it down.
Correct. Yeah, at this and then later, of course, devaluing the dollar. It's messed up in all ways legally, as you point out. But it's just, I then think about when people discuss 6102 type things around Bitcoin. Well, don't forget, it gets more valuable. I mean, that's a big bill if the government thinks they need to come up with $1.5 trillion or whatever. At least the market value is pretty damn clear for what the government would need to pay for it. So, and I really appreciate the carving out this notion of what rights the government did not grant you, you still reserve the others. What was the name of that doctrine or that?
It's the Ninth Amendment. So maybe we can even just read it. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the United States Constitution is it's a document of enumerated powers. This was really important if you read what the framers said, that this is not a list of, there are some, in fact, I guess to back up, it was very controversial among the framers whether they were going to publish a Bill of Rights at all.
Yeah.
The reason it was controversial is because the Constitution is a document of enumerated powers. This is not a list of things that the government can't do to you. This is a list of things the government is allowed to do. And the rest of it are your rights, right? It's enumerated powers. It is opt-in, not opt-out. And the Bill of Rights is really just a reminder among all of the things that you have the right to do, which, by the way, is the universe of everything not touched on by the text of the Constitution, that not enumerated there.
Yeah.
Here are 10 things that we really, really want to underline. And importantly, one of those things is the fact, it really just a reminder that the rest of the Constitution is enumerated powers. Those are the powers the government has. And then specifically, the enumeration in the Constitution of those rights will not be construed to deny or disparage others retained by the people. If the Constitution doesn't give that right to the government, it's yours.
What I'm curious about is because the way it is that that process, almost that social process of remembering rights we may not have known we had, or like suddenly discovering through the impingement on certain rights that we're losing something we had. That's a curiosity for me, or how, in this way, like self-custody, because it's now kind of possible in this new way, is giving us the ability to kind of reflect on, like, oh yeah, well, this is something we maybe always had. It now might be in danger. Do we want to take steps like what the Clarity Act is proposing to just kind of really remind everybody that this is the case? Like, what are your thoughts on that, or how do you?
Well, there's language in the Clarity Act about self-custody that was drawn from another bill called Keep Your Coins, which is about retaining the right to self-custody.
Yeah.
Because that right, I think, is in the Constitution, that's a little bit less important than a different part of the Clarity Act, which is about protecting non-custodial developers and service providers. The language about non-custodial developers and service providers, this is not a question about what's in the Constitution. It's a question about what's in another law called the Bank Secrecy Act that applies various requirements for regulated financial institutions called money service businesses. And one type of a money service business is called a money transmitter. And the question is, who in the Bitcoin economy is a money transmitter or money service business for the purpose of the Bank Secrecy Act, which comes with all sorts of requirements like KYC, AML, that non-custodial actors might not be able to comply with, even if they wanted to. If you write a open source unhosted or non-custodial wallet, you just can't comply with the Bank Secrecy Act vis-a-vis that wallet. You can just put the code on GitHub, people download it, and it is what it is, right? It's like asking someone who developed a USB cable to KYC everyone who transmits data over that cable. It doesn't work. And so specifically, the Bank Secrecy Act says that you are a money transmitter if you accept and then transmit value or currency, in this case, what they would call convertible virtual currency, including Bitcoin, on behalf of the public. And you'd think that between accepting and transmitting, you would have to have that value or those funds. You'd have to custody or control those funds.
Yeah.
Just logically entailed by accept and then transmit. And in fact, the part of the U.S. government, which is a subsection of the Treasury Department called FinCEN, which enforces the Bank Secrecy Act, they put out multiple pieces of guidance sort of explaining what everyone thought to be a custodial versus non-custodial distinction for the application of who is a money transmitter. So a custodial exchange is a money transmitter. A decentralized exchange that's just a bunch of smart contracts on a blockchain is not. A hosted or custodial wallet where someone is holding your Bitcoin for you and you have an account with them, and it's basically a credit, that's money transmission. A non-custodial Bitcoin wallet, which is just software where you're generating your own private keys, is not. So on and so forth. One of the sort of most interesting parts, they get into multi-sig wallets, and they say that if you are a multi-sig wallet provider or you provide services around multi-sig wallets or collaborative custody, sort of like what Unchained does, you are not a money transmitter unless you have total independent control of user funds, which is an important nuanced distinction. If you're holding a backup key for customers, you're not really a custodian, right? You're providing a service, but that service is not holding people's Bitcoin. You can't rug them. They are essentially holding it in their wallet. If they're sending Bitcoin, necessarily they are the ones sending it, even if you're assisting with holding a key. And then when it comes to privacy tools, there's an important distinction in FinCEN's guidance between what they call anonymizing service providers, which they define as someone who provides a service where you accept and then transmit funds in a way that obscures the flow of those funds, versus a anonymizing software provider where you're providing software or infrastructure that allows people to send their funds in a obscured or private way where they are transmitting the funds using your tech. And an anonymizing software provider is not a money transmitter. An anonymizing service provider is. And that was a pretty clean distinction until 2023 with the Tornado Cash case, and then 2024 with the Samurai Wallet case, where for the first time, the Department of Justice through criminal prosecutions, was alleging that providers of non-custodial tools, a smart contract in the case of Tornado Cash and a CoinJoin in the case of Samurai Wallet, constituted money transmission under the Bank Secrecy Act. The government later retreated from that specific claim, but ended up getting convictions in the Samurai Wallet case through guilty pleas and Tornado Cash through a jury trial on the theory that the defendants in those cases, all software developers, were somehow transmitting funds. And that is very dangerous precedent that we're going to have to, either through the Clarity Act or through appeals in the courts, overturn. Because if someone who offers a non-custodial CoinJoin where users are moving Bitcoin from one wallet that they control to another wallet they control, and in between there's no custody, there's no third party, it's just a Bitcoin transaction, right? It's just a collaborative transaction with other people through the mempool. If that's transmission, then so is everything.
Is there a distinction? Because I've heard it put that the charges were something more in the order of a conspiracy to commit thing.
Yeah. So specifically, the charge is conspiracy to operate an unlicensed money transmission business, where
that's not necessarily saying it is yet one of those. It was like I was planning to, or like it had, or has that at least plain language?
So a conspiracy is what's called an inchoate charge. It doesn't require that the thing happened. It is that you agreed with at least one other person to do a criminal thing, and then you took some overt act in furtherance of that agreement. Here, I don't know that that particularly matters for the charge. The thing that really legally matters here is what is the sort of object of the conspiracy?
Wilson's activity,
and that's the unlicensed money transmission. And there were originally two theories, called two objects of the money transmission conspiracy. Initially, there was what's called subsection B1B and then subsection B1C. Subsection B1B is what the charge sounds like. It's you needed a license from the federal government. You didn't get that license and you engaged in the money transmission business anyway. Based in part, I think, upon advocacy from groups like BPI and Coin Center and DeFi Education Fund and lots of people who sort of wrote in to help Blockchain Association. And I think probably more importantly, this document called the Blanche Memo from the Deputy Attorney General saying, hey, we're not going to announce new novel theories of what money transmission means by throwing people in prison through criminal prosecution anymore. The government dropped the B1B object of the conspiracy and is no longer directly saying in these criminal prosecutions that the Bank Secrecy Act required the defendants to get a license with FinCEN. And so they left what's called the B1C charge, which actually has nothing to do with a license. You can be guilty of B1C even if you have a license. The B1C charge that the defendants either pled guilty to or were convicted of at trial is that whether or not you had a license, whether or not you needed a license, you knowingly transmitted funds that you knew to be the proceeds of crime, which again still begs the question: did Roman Storm, did Keone, did Bill, did they actually transmit funds, or was it their users that were transmitting the funds by signing with private keys? And I think the answer, logically, legally, morally, has to be the latter.
So, do you look at it as somewhat binary, or an impression for me is that there was some win in these things being dropped in terms of like it's what it presages for the future. Like it does clamp this down a little bit, but then how yet serious is or alarmist to you is that last one? Like,
yeah, in terms of precedent, it is good that the government is no longer directly saying that if you provide a non-custodial service or publish non-custodial software, you have to get a license as a money service business or money transmitter. That is a positive step, and that helps somewhat with the precedent from these cases. That's part of the good news. The other good news is I think the Blanche Memo strongly signals that the current administration will not bring similar prosecutions like this. I don't expect there to be another similar case during the Trump administration. The bad news is that the theory on which these defendants were convicted still says that they transmitted funds, and it doesn't require they intended to help criminals. Each of these defendants was also, by the way, charged with a conspiracy to commit money laundering, which requires that you intend to help criminals transmit funds. But there's a really important legal difference between knowledge and intent. The easiest example I can give to help people understand this is if you're an Uber driver and you have someone in the back of the car and you ask the person where they're going and they say, I'm going to rob a bank, even if you drop the person off at their destination knowing that, you're not guilty of a crime. You didn't aid and abet someone robbing a bank, even though you knew that you were taking someone to rob a bank. However, if you're the getaway car and the person calls you and said, "Hey, I robbed a bank," or even beforehand, if the person says, "Hey, I'm going to go rob a bank. I need someone to drive me there in a non-conspicuous way. Will you drive me there to help me?" And you say yes. Yeah, now you're guilty of either a conspiracy to help rob the bank or of aiding and abetting. And that difference is between did you know something versus you intended it, you did it on purpose. And so the money laundering charge would require that the defense either built the non-custodial tech to help criminals, which is very hard to prove, as opposed to just helping people spend money privately, or in the operation of those services, they intended to help criminals, which in most cases is really not what any of these folks are doing. Whereas this B1C charge, the two elements are one, the defense transmitted funds, and B, they knew that at least one of those users was using it to launder criminal proceeds. But everyone who builds a big enough tool knows probably some criminal's going to use it. Apple knows people are going to use their MacBooks to do crimes.
Yeah.
Right. Victorinox knows some people are going to stab each other with Swiss Army watches. And so the knowledge component, because it doesn't require intent, it's merely knowledge, that's really not much protection. And so if the only thing left then is that you are a money transmitter, and you're a money transmitter by virtue of offering software and sort of services like in the Samurai Wild case, these coordination services, which is basically a digital bulletin board to help other people find other people who want to do the same transaction size as you in a collaborative coin trading transaction. If that is money transmission, when you never have custody or control of funds, the problem is like, so is publishing just a normal custodial wallet, so is running a node, so is mining in the Bitcoin space, right? You're adding transactions to the blockchain. So is running a eCash mint. So is running a Lightning routing node. Really, almost anything that you can do besides holding your Bitcoin on Coinbase or owning shares of iBit is going to be, the people who create those tools could be guilty of unlicensed money transmission.
It drags it all in, and even on, and even just your Apple and other examples, it just like kind of has this, where does it stop? What is some of the, if you had a Steelman, either the prosecution in a case like that, which may come down to either political motivations or other things, or if you had a Steelman, just kind of what elements are there that would dispute or have it take issue with the language that's in the Clarity Act around self-custody? What is going on there? What?
So to Steelman, why the prosecution happened? I guess I would first say I don't think that the prosecution was straightforwardly politically motivated. There actually was a politically motivated version of this called the Digital Asset Anti-Money Laundering Act, which was a bill that was proposed by Senator Elizabeth Warren, which what that bill does is similar to these criminal prosecutions. It just says everyone in the Bitcoin space, miners, node runners, well, they're all money transmitters. And Elizabeth Warren is smart and knows full well that is, without calling it a ban, that is effectively a ban on Bitcoin. That's not what I think the Samurai Wallet and Tornado Cash cases were. I think what that was about is a real concern about money laundering using crypto tools, coupled with a indifference in the Biden administration towards collateral damage for the Bitcoin and crypto industry, right? It's they didn't really care if this hurt software developers, even though that's not what they're necessarily trying to do. And the sort of Steelman version of that concern is that at least a perception that non-custodial technology is a loophole in the Bank Secrecy Act. The Bank Secrecy Act, as we said before, was written at a time where sort of necessarily any electronic transfers would be intermediated. Now they're non-intermediate transfers. If we just exempt those from all of the rules that we apply to normal financial institutions, then we've created this giant gaping loophole that criminals can use to launder money. Now, I think that's wrong for all sorts of reasons. One is it's just not workable. There's no limiting principle once you start to apply money transmitter regulations to non-custodial technology. You get to a point where it's, the guy who chopped down the tree for the wood that made the paper that was in an envelope that one criminal used to pass dollar bills to the other needs to KYC. Like, that doesn't make any sense. So it needs to be more narrowly tailored. From a statutory perspective, the Bank Secrecy Act, whatever you think it should say, what it says now is accept and then transmit. That's not what's going on with non-custodial technology. And then there are all sorts of neutral tools, the internet, computers, cables, whatever, where we don't apply KYC-like rules to them. And so I don't see why digital asset or Bitcoin rails should be any different. If the government wanted to pass a new law that withstood constitutional muster, all the protections we have in the Bill of Rights, and that puts some limit on privacy tools, and that could be debated, that might be a different story. But that's not where we are now. Where we are now is trying to bend laws from the 1970s to cover technology. It just doesn't cover. In terms of the Clarity Act, I think the Clarity Act language is great. There are some limitations on the protections in the Clarity Act in Section 109 for non-custodial developers. It says it defines non-custodial developers and non-custodial service providers, I actually think, in a really good way that captures everything we want. And it says, if you are a non-custodial developer or non-custodial service provider, you are not a money transmitter if you're doing, and then it enumerates 3 things. And I don't think there's any reason to have to enumerate anything. If you're non-custodial, you're not a money transmitter, period. My understanding is that there were people in the Treasury Department who basically lobbied for and got that limiting language. And so I wish it wasn't there. And I am currently the version that is the Senate discussion draft of this bill maintains intact those 3 sort of enumerated areas. I would love for that to go away. But the truth is, wearing my lawyer hat, those 3 enumerated things are broad enough that I think I can make a good argument that much of what we want will be able to have covered by the protections there, including Samurai Wallet and Tornado Cash. I don't think, as written, you would have been able to bring either of those prosecutions.
So there's this. So there's the Bank Secrecy Act is kind of, in that motivating case, or like what was there in creating the Bank Secrecy Act, and then the context in which it was in. And then we now kind of find ourselves, and that was in a place of just, we almost couldn't imagine a non-intermediated.
The Bank Secrecy Act was passed in 1970.
Yeah.
It was in response to a really big wave of organized crime in the United States at the time. And, for example, the mafia would hide a lot of its money in Swiss bank accounts. And the FBI would go to U.S. correspondent banks and say, hey, do you have any records of this mob boss sending a bunch of money to Switzerland? And the bank would say, sorry, we don't keep records like that. And so the Bank Secrecy Act was, I think, originally a good faith attempt to require United States banks to keep records of their customers. That's where KYC, know your customer, comes from. They have to file suspicious activity reports, or SARs, if they see something, like some shady guy with a Tommy gun sending millions of dollars to a Swiss bank account. And in its original form, I don't actually think that the Bank Secrecy Act was that big a boogeyman. The problem is it's become this Frankenstein law that is now basically a digital dragnet. So it's been amended quite a few times. The 2 biggest amendments were in 2001 with the Patriot Act after September 11th, and then again in 2020, and that really expanded the reach of the Bank Secrecy Act. And then specifically this concept of a money transmitter came from the Patriot Act addition to the Bank Secrecy Act, which was really meant to cover what's called the hawala system, which is very popular in parts of the Middle East and Africa, and something that the government was very worried about in terms of terrorist financing, where you had these people called hawaladars. And this is like an ancient system, I think, that originally came from the Silk Road, where you give money of some sort to a hawaladar at one end, they pass credit or IOUs between each other. It's a little bit kind of like how the Lightning Network works, and then hawaladar on the other end gives it to them. But what's interesting is if you look at this sort of accepting and transmitting value, the ledger in the hawala system that this language was meant to cover, the ledger is controlled by the hawaladars, by the people who are regulated here. And then the value that's being transmitted, it's not the money, right, that goes in one end or the money that comes out the other. The value that's being transmitted are these IOUs that are very literally accepted and transmitted by the hawaladars one to the other, that allows the person on the other end to get the physical currency out. And that's just not analogous to for example, the Samurai Wallet case, where the value that's being transmitted isn't an IOU at all. It's Bitcoin on the Bitcoin blockchain. And the ledger is the Bitcoin blockchain. It's not controlled at all by the defense in this case. They just built a tool, sort of a user interface that allowed users to interact with that network.
And so your comment about the BSA, the Patriot Act, was concerned about that type of system, and so then therefore enforcing within those Wallador.
So the Bank Secrecy Act, in creating this concept of a money transmitter and the case law and the regulations and how that concept applies, that was created because of these hawaladars, which the United States government was worried were responsible for terrorist financing in the aftermath of September 11th. And it's that same concept that was created for the hawaladars that is being used to apply in these cases to non-custodial Bitcoin and crypto tools.
So we're talking. So some of the Steelmanning, or the impetus of the force, as I'm trying to characterize, paint a picture for kind of the antagonists here, right, or like the parties that would seek to eliminate self-custody capabilities and or non-custodial service providers. They're worried about what the BSA was intended to do in terms of help stop illicit financing. They're worried about things not being within the scope of the government apparatus that can do that. And then,
it's really mostly that last bit that you said. The people that are against self-custody, there tends to be an ideological bent. It is a specific part of the Democratic Party. You get some sort of moderate Democrats and moderate Republicans who are national security hawks, and they're very specifically concerned about terrorist financing or the dark web or child pornography. That's a smaller group of people. The bigger group of people that are against self-custody have an ideology that the solution to every problem is more power for the federal government. There just is a group, specifically of the Democratic Party, that feels that way. And there are a lot of ways in which Bitcoin, both the asset and the network, is incredibly ideologically neutral. It's money for enemies. You can use it if you're a dictator. You can use it if you're a freedom fighter. You can use it if you're a libertarian. You can use it if you're a communist. The one way in which it's not really neutral is that it takes certain powers away from powerful nation states. Most specifically, to the extent that Bitcoin gets adopted as base money, it takes away the power to control the money supply. It also, to some extent, takes away the ability to censor transactions. The United States, when Russia invaded Ukraine in 2022, froze Russia's treasury reserves. We proved that U.S. treasuries are not a neutral reserve asset in that regard. We get to decide what the supply is, and we get to decide who gets to keep them versus having them frozen or deleted. You can do neither with Bitcoin. And so if your ideology is that the sort of free market is by and large bad and creates perverse bad results, and that the way to get to a better society is sort of more and more state control, where if you're Steelmanning it is with democratic buy-in and people express preferences, and there's sort of a social contract, and we want sort of the rules of the road economically, politically, in terms of speech, to be controlled by laws passed through the people's representatives. Then Bitcoin makes that harder, and specifically sovereign use of Bitcoin makes it harder. People holding IBIT, not a huge deal in that regard, but if you're want the government to have more and more control over how and when people are saving versus spending money, if you think that the velocity of money is really important, if you are worried about rich people hoarding money and getting richer, then maybe the ability to save in a perfectly scarce, censorship-resistant form of money undermines your power. If you think it is critically important that the government be able to surveil and stop transactions that they don't like, either for very serious reasons like terrorist financing or crime fighting, or for policy reasons, which we saw with Operation Choke Point 2.0, then Bitcoin makes that harder. It takes away some of that power. This is, for example, why we've seen such antagonism against Bitcoin in China, which is a society that is really centralized and top down, where Bitcoin allows more private use of money. It allows capital flight, right? Both Bitcoin and stablecoins. I live in New York City, and Hudson Yards is largely built with expatriated Chinese money from wealthy Chinese people that didn't want to leave their money in a system where it can be easily confiscated. How much more convenient is it for anyone who has a smartphone to be able to hold a sort of risk-on asset in the form of Bitcoin, or risk-off asset in the form of Tether, just by memorizing 12 words? This is a very powerful grassroots technology.
I'm struck too, just between the characterizing the antagonistic threat, or the camps that look for that government power, the government answer to implement controls on financial activities, and that the setup with the Bill of Rights and just that early intention to have a limited government. And so that's where it feels like a lot of this, it's like self-custody is kind of one just way into like one of the oldest arguments in our country.
Yes. I mean, I would not pretend to be neutral as between these two worldviews of sort of maximizing for individual liberty versus sort of state control. I think one of them embodies American values, as literally we saw in the text of the Constitution, and one of them is antithetical to that. And of course, there are gray areas, right? I mean, the Constitution doesn't use the word Air Force, but we think it's constitutional for the United States government to have an Air Force. That's part of the commander-in-chief authority of the government. There are terms in the Constitution like interstate commerce that do give the federal government pretty broad authority, and we need to live in a society, and there are things that are maybe better done sort of by a centralized federal government than left to the states. And so it's not like a maximalist thing one way or the other, but if you're talking about like what should your orientation be, if you're looking at the Constitution and you're looking at almost anything that was written by the framers, it's clear that this is all about limited, specifically enumerated power by the government, and the rest of it is the rights and the dignity and the freedom of the American people themselves.
If we had Bitcoin when the Bill of Rights was initially drafted, do you think they would have included anything about the right to self-custody, or do you feel
I mean, absolutely. I mean, if you look at the first 4 amendments in particular, right, these are things that the framers were sort of stomping their feet about. The government is not going to do these things. The first is they're not going to impose a religion on you. They're not going to impose political speech. They're not going to censor political speech. They're not going to tell you who you can associate with or not. The Second Amendment, the right to bear arms shall not be infringed, right? I don't know how big gun culture was at the time of the founding, right? I mean, there were militias, and that's what the sort of preamble of that text talks about. But it's not like they could have said you have the right to have firearms for a militia. But no, it says the right of people to bear arms shall not be infringed. The Third Amendment is about quartering soldiers, right? This was about you don't need to have redcoats living in your garage. Like that sucks. That they eat weird British food. I absolutely think that especially if you had something analogous to the history we've had with Bitcoin so far, where you have real opponents in the legislature to the right to self-custody, to the right to transact in a free peer-to-peer basis, I would like to think there's strong basis to think that would have been included in the Bill of Rights.
And then what do you think is the right strategy from here? It may just be past the Clarity Act. I heard that part of what you like about the course that's on is not pretending as if this isn't already a right, but just kind of it's the clarity, literally called the Clarity Act, I guess. I think
with regard to self-custody specifically.
Yes. Yeah. With regard to self-custody, I think separate from the non-custodial services and developers, but because it's even a way I'm mindful of going about the series, trying to publish or have good content come out about this, that there's a version of strategically, dude, don't make a big deal. Just let this thing pass. Like, don't even just like put attention on it too much. I'm mindful though that someone can come out with some big guns later, and I'd like this side to have the ammunition ready, or that this is, I feel like, a an important moment over the next couple of months.
It's going to come up. It's going to be a fight. Elizabeth Warren is all over this, and the thing I'm most worried about is not that we're going to draw too much attention to it. It's that the Clarity Act is not mostly about the stuff that we're talking about.
Yeah, it's
3 pages of a multi-100-page bill. The Clarity Act is mostly about legalizing token launches and drawing a line between what kind of crypto is a commodity versus what kind of crypto is security. And as long as you sell your crypto tokens along with an equity fundraise for crypto startup, we're just going to say they're not securities, and that way Andreessen Horowitz can make a lot of money. That's mostly what it's about. And there are billions and billions and billions of dollars for companies like Andreessen Horowitz, like Coinbase, in making sure that that happens. And they have a really big lobbying force, and Bitcoin doesn't have a CEO. We're doing our best at BPI, but we're a small team, and we're furiously fundraising. But reaching the firepower the crypto lobbyist has it's just a really high bar. And the thing I'm most worried about, again, sitting here in the summer of 2025, is a trade where we get a version of the Clarity Act passed that legalizes ICOs, but it strips out the non-custodial protections. Now, that would be a short-sighted thing for even the crypto Web3 folks. If crypto has any value, it's because these are peer-to-peer transfers.
Yeah.
And fine, you can maybe dupe the public in like one more cycle of promising hype without substance. But if DeFi is going to be anything, if decentralized autonomous organizations are going to be anything, if all of this sort of ownership layer of the internet is going to be anything, it's only going to be anything if it's able to truly run on decentralized peer-to-peer blockchain rails. And so mortgaging that to get the quick payday is just really strategically bad. So I don't think it will happen, but this is the thing to sort of vigilantly keep an eye on. And I don't think we have the luxury to let this slide under the radar, because our opponents, specifically Elizabeth Warren and her camp, they are laser focused on the two sort of politically difficult things with Clarity are going to be this issue where people are going to say it's about national security and terrorism and child pornography. And if you leave Section 109 and you're in favor of all those things. And then the other fight is going to be about sort of the president's family and conflict of interest. And those are both going to be politically difficult fights.
Yeah. So you see already the kind of Elizabeth Warren camp revving up.
Yes. No, definitely. I mean, I've been to various Senate offices and have been told that explicitly.
So then what else? So from a strategy, it's not then about it's sort of parts of the strategy is remind the people with so much at stake here, what is also at stake in terms of the camp looking for ICO legislation and things like that, and they would be it's reasonable, they would be rational enough to want the self-custody and the developer protections in there. So there's kind of a way where we're sort of hitched to that.
Education is the most important thing. Explain to people what this technology is and what it isn't, and to make the analogies to the USB cable and laptop, and that's what we're talking about. We're not talking about something that really generally looks like a bank.
Yeah,
just isn't. I think some of it is explaining the important use cases for this technology, the way people are using federated eCash mints in the global south, the way that the Lightning Network allows for sort of non-extractive remittances. The way that this really benefits sort of the least among us in the way that should be really run alongside especially the progressive values of Democrats who might otherwise be against us on this. How this is analogous to things like Section 230 that allowed the internet to thrive. If we regulated YouTube the way we regulated the big three networks in the 60s, we wouldn't have YouTube. And when you have a technological paradigm shift, you need to have a regulatory regime that accounts for it. And that's what this is about. So education is the biggest thing, combating some of the specific misinformation about how much this technology is used for crime, which is actually much lower than you think, and a lower proportion than fiat rails. And then, making sure that you speak to each of it's the senators, we're going to have to win over the senators on issues that they can understand, that they care about, and meeting them where they are.
There's another Keep Your Coins Act that was recently proposed in the Senate. Is that right?
So the self-custody language and the non-custodial protections from the BRCA are each, in the Clarity Act, are each taken from separate standalone bills. So the self-custody language comes from a law called the Keep Your Coins Act, and the non-custodial developer language comes from an act called the Blockchain Regulatory Certainty Act, or the BRCA.
Yeah, thanks a lot for doing this. I know we didn't
my pleasure.
Peer-to-peer rights fund and some of that stuff, but I think that's a follow-up thing where, like, however I can help boost that, or either personally donate, or at least but help funnel some interest in Bitcoin there would be great.
Yeah, really appreciate it. And let me know how I can be helpful anytime.
Will do. See you, Zach.
All right, talk to you later.